Good morning, sir. Are you Hakim Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 25 DCCR 0843 with the first-degree felony offense of aggravated robbery. And Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at,
I think 600,000.
okay. And Ms. Malfino, you have a witness. Do you want Ms. Malfino to go first? Would you rather go first, or
No, I'll first. She can go first.
go ahead, Ms. Malfino?
Okay, Judge, just for purposes of the record, I would tender to the court just for ease of use, State's Exhibit Number 1, which is a probable cause affidavit in this case, and I will call Detective Kennedy.
Any it's in my file. Do you any
Right.
objection
No
to,
objection.
States 1 is admitted for purposes of this hearing. Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead.
Could you please state your name for the record?
Dwight Dean,
And how are you employed?
Beaumont Police Department,
How long have you been in the city of Beaumont?
31 years.
You're a certified peace officer in the state of Texas.
Yes, ma'am.
And you and I discussed this case involving Hakim Thomas as well as his co-defendant Tyree Hartley last week. And we're here in order to address the bond in this case. Can you briefly go over your involvement in the case and your familiarity with the facts in this case and why you think it's important that this defendant remains in custody?
My involvement is through Southeast Texas. I love that task force. We deal with auto murderers, and a new offense was added to our penal code called jugging. We believe that this offense started out as a possible jugging on breaking into a car, and which ended up into injury with two of the guys involved. One standing here as well. That ended up injuring an infant child through coordinated efforts of us locally here in Beaumont, myself, officers on the street, along with deputies of the Chambers County Sheriff's Department. We're all involved to have these guys arrested.
So they did actually flee from this jurisdiction into Chambers County after this offense, which again involved an infant child in the back seat of that car being injured when they attempted to break into that car and retrieve the money that the child's mother had obtained from the ATM.
That's correct. The ATM of the bank, that the vehicle, the dad left the vehicle, and the mother and the infant child were in the back seat of the car. Not only did they break into the car with shattering glass on top of the baby and the mother in the car, with her continued efforts during the crime itself, they didn't stop. They kept on. Once they were successful, if you could say that, in any kind of theft, they did flee from here and were actually found in the same vehicle.
And did you subsequently with Detective Andrew learn that both of these defendants in this case had committed similar types of acts in various jurisdictions across Southeast Texas, Harris County, Fort Bend County, Austin, etc.?
Yes, ma'am. Some of it did happen that actual day, and of course some of it was put together, shredded the background, and those are after the arrest.
And is it your position, based on all of your years of training and experience as an officer here in Jefferson County, Texas, that to maintain the security and well-being of the safety of the citizens of Jefferson County, that it be best that pending prosecution of this offense, this defendant at least remain with some kind of a high bond from this court?
Yes, ma'am.
Thank you. I'll pass the witness, Judge.
Thank you. Mr. Lewis?
Yes, just briefly. Now, you said you were definitely part of the investigation of this allegation, correct?
That's correct.
Now, during your investigation, was it ever shown that a weapon or any deadly weapon anything was exhibited to the plain witness or
Not that
anything?
I'm aware.
So there was no weapon involved as far as we know?
Not that I'm aware.
Okay. And as far as your investigation as it relates to my client, was it any statements or evidence that showed that he was involved with the actual breaking of that of the glass or possibly injuring the child involved?
Not that I'm aware.
Is there any evidence that would show that they even knew it was an infant child in the car at the time?
No, it's not.
I'll pass the witness, Judge.
I've done further, just arguing.
Thank you, Officer Dean. Any witnesses, would you wish to call your
No.
client with regard to his financial status? Mr. Thomas, come back around. Best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Mr. Thomas, as far as your financial situation, you're currently in custody, correct?
Yes, ma'am. Yes, sir.
Now, do you have any money saved up that could be used for your bond?
No, sir.
Do you have any property that could be sold or vehicles or anything of that nature that could be sold in order for your family to come up with your bond?
No, sir.
Who would be responsible in trying to come up with the bond amount for you?
My mother and my wife.
Your mother and your wife? Have they been in touch with any bondsmen
Yes,
currently? Okay. And from the information you received, how much of a bond or commitment they will be able to make to try to bond you out?
The complete bond amount, between $70,000 and $100,000.
Between $70,000 and $100,000. Okay. Now, were you employed before you came to custody?
No, sir.
Do you have any employment or anything available to you if you're able to make bonds?
Yes, sir.
And what would that be?
Being a helper to my wife's father in his CDL truck.
Okay. And that will give you enough money to be able to take care of any pretrial conditions or anything you need to do with
Yes,
your,
sir.
your representation in this case?
Yes, sir.
Okay. I pass the witness in regards.
Ms. Malfino.
Mr. Thomas, tell the judge a little bit about your criminal history, starting when you were a juvenile.
I have no juvenile record.
Were you in trouble as a juvenile over in Harris County?
No.
What about your theft, your state jail felony theft from a person, which is basically another way of saying,
That's
who
not
did you
juvenile,
rob?
no.
Don't talk over, okay?
I
Just
think
wait till she's finished talking so the court reporter can take one at a time.
Yes, ma'am.
Where was that?
Go ahead, Ms. Malfino, you might want to read.
Your theft from a person, which is basically a robbery, where was that?
2021,
Where, in Harris County?
Rosenberg.
Have you been in trouble in San Antonio?
No, ma'am.
Have you been in trouble in Austin?
I have a pending case in Austin right now
For what?
for a robbery.
Do you have any kids?
Yes, ma'am.
Someone would have done this to your wife and your baby would have been in the car, what do you think that person should get? Prison time?
I don't understand this.
I don't have anything for you, Judge.
All right, anything else?
Nothing else for this witness, Judge.
All right, you may make argument.
Judge, as far as this case goes, you've seen that it is charged as aggravated robbery, but it's one where we don't have a deadly weapon involved or anything like that. The biggest issue, I think, with this situation, of course, is my client does have some criminal history and lives out of county. I believe there's already some bond conditions in place for him to have the GPS monitored and be able to go to be in Harris County, come back, of course, for court and everything. We are asking for a bond in between $75,000 and $100,000. I think that, including with the GPS monitoring and everything, would be enough to cover, one, secure his return to court, and also, of course, satisfy any public safety concerns while these cases are pending. He does not have a hold from the case in Austin, because I believe he's still in bond for that
I'll
situation.
find it out while I'm in custody.
Right. So he is on bond for that, so he will be allowed to be released. My understanding, there's not been a court date set up there. We don't anticipate that interfering with us here as far as any type of issues. And from
When
talking,
did you make bond on that case?
July, sometime in July.
Okay,
I'm not sure the exact date.
okay, that's
sometime
fine.
in July.
All right, go ahead.
but from talking with his family, they have been involved with this case he has going on up in Austin, and that I think that actually will be resolved pretty quickly, and won't interfere with what we have going on here.
What, if anything, and Officer Dean may know about, I know you noted some other counties where there were some potential cases or issues. Do you have any other information on those?
I have reached out to Fort Bend, Judge. I have had difficulty in getting a final answer. A charge looks very looming. How they initially filed them, I think one of the impediments that I'm up against is in Harris County, Fort Bend County, that surrounding area. They have dropped a lot of stuff down to some very low amounts of time. So it looks like if an initial charge comes in as an aggravated robbery, it ends up 6 months later as theft from a person in the state jail. So that's really the totality that I've been able to.
Do you have any other
obtain from
additional
the
information?
co-defendant.
No, ma'am, that's exactly what I was gonna say. It looks like there's been some initial charges that were actual aggravated charges that were bumped down.
Okay.
And I would also ask if you would take judicial notice of his incident of behavior report.
I will. I also have, and I think you guys should have received 7 pages of incident reports from the jail as well, which obviously y'all know my thoughts on that. And so anything else?
No, Judge, and the state does not object relief necessarily in this case, just not, I would ask that it remain in an amount at least above $350,000.
And Judge, if I may, to the jail incident reports, I think those were like early on when he got into custody. Of course, Mr. Thomas did speak about those and how, of course, he should conduct himself out there, and I don't think he has had any other issues since that conversation.
I guess my concern, and I understand from the probable cause that the allegation is that Mr. Thomas was the driver of the car, but I don't know that that makes it any better whatsoever, because it doesn't sound like there's any evidence on why he and Mr. Hartley were in Jefferson County, if they're from Harris County and that's where he's gonna live, why they're in Austin, why they're wherever they are, other than to come into our county and break into people's cars or jug, which has become a huge issue. And so based on the evidence today with regard to this specific offense, based on the jail incident reports, based on the information received through, again, take judicial notice of the court's file, the magistration information as well, the fact that there is at least one pending case that is similar, others that sound similar, just with some different outcomes, I don't think it is in anyone's best interest that Mr. Thomas have any relief today, and so I'm going to deny the motion to reduce the bond. We will reset the case and for an announcement and see where we get. All right, thank you, sir, for being here, Mr. Kane, Officer Kane. All right, do I have okay, this is cause numbers 22-39100 and 22-39101. Are you Letitia Tebow? And Ms. Tebow is currently on probation for failure to comply with sex offender registration in each of these cases. I looked this up. I think there may be, and Ms. Simon's here, this update report says 2 10-year adjudicated probations, but it was a 2-year term
It was 205.
205.
2 TDC over 5, correct?
Excuse me, sorry, that was an error.
Okay, just making sure. And so Ms. Tebow was previously here, entered pleas of true to counts 2 and 4 in the motion to revoke probation. And I've received the updated pre-sentence report. Have you all received that updated report?
Defense had it done.
State has to.
Any additions or corrections to that other than the one that I already made?
None from the state.
Nothing but that.
And there was no agreement. Is there any evidence with regard to the other counts, Mr. Hoffpower?
Any new, meaning new failed to register.
No.
The
I don't know.
Florida-
She pled true to counts 2 and 4, so there's
Correct.
obviously some other counts. Do you have any
Right.
witnesses or evidence
No,
with
no.
regard to those other counts?
We're gonna full abandon those counts, we'll just proceed on 2 and 4.
Okay.
Other than I call my probation officer, but, you know, I like her opinion.
Okay, so I guess there was an arrest in
It's in Florida.
Palatka, Florida. Okay. Hold on a second. Let me get
Putnam County.
Okay, so count 1. Why don't you have any evidence with regard to count 1 if your probation officer's here?
We can call it. I'm sorry, apologize, Your Honor.
Ma'am, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
Would please take the name from the record, please.
Sarah Simon.
I'm assuming are you the probation officer assigned in this people?
I am.
Okay, and how long have you been first supervision officer?
Year and a half.
Okay, and throughout the time that you've been a probation officer, has you complied with the terms of her condition? In either one of the cases?
Speak up, please. I'm sorry.
Okay, no, she has not.
She's not.
Yeah, okay, in what instances has she not complied?
Steve-O has had consistent reporting habits. She was not paid towards her SSPs. And she's introducing it to
Was she allowed, first of all, was she allowed through her probation here in Texas to venture out of the state and be in Florida?
She did not.
Okay, she wasn't allowed?
She was not allowed.
Is she allowed through her reporting as a sex offender to move or go to another state and have no probation? I mean, is she allowed to leave the state?
Not without.
She pled true to that.
Okay.
Count 1 is that she has not reported since January 27th of 2025.
Is that true now? That she,
That is true.
and intermittently, or she is fully, she's been called absconder?
She is absconded.
Okay, since that day?
Yes. Or, 90 days after that comes in January, she became absconded.
She been okay, and since she reported since the time on which she was arrested?
She has not reported
Have you spoken to her at the jail?
at the hearing.
All right, did she give a reason for why she didn't report?
She did not.
At this time, I'll pass it on.
Okay, I also would like to know, Ms. Simon, were you able to confirm in any way the arrest? Obviously, she's gonna say she didn't do it, and that's okay, but if she was actually just, whether an arrest happened in Florida?
Yes, I did obtain an arrest report from Florida.
PC, okay. But do you have a problem cause, or you have a full offense?
The full officer.
Okay, for what crime was she arrested?
There's 2. I think one was petite theft and then obstruction by disguise first.
Okay. Was all the same incident?
Yes.
And what date did that occur, according to the law?
June 29th, 2025.
And were both those committed
Objection as far as committed, Your Honor. I don't object to her listing evidence as far as an arrest. but
An
As far
arrest.
as the actual commission, it could violate a right to front cross.
Did the allegation occur?
Yeah, the arrest.
The arrest occurred while she was on probation.
Kelly, this just did something again.
Correct.
And those haven't been resolved to your knowledge.
Not now.
May I proceed, Your Honor?
Yes.
She initially failed to report in January, is that right, of 2025?
That was the last face-to-face contact I had.
January 2025. Then arrest June 29th of 2025.
Yes.
So February, March, April, May, June, 5 failures to report. And she went into absconder status March of 2025?
Would be April,
April,
like 90 days after.
90, so April 2025, she became an absconder. 2 months after that, she was arrested in Florida, is that right?
Right.
So you were aware if she was in Florida, which state, when were you made aware that she was in custody in
I
Florida?
received a phone call from somebody that let me know that she was arrested and in jail in Florida. And then that's when I obtained this arrest report.
So when did there was an MTRP entered into NCIC, I guess, after April? Was there an MTRP and that's why Florida advised you there was an active warrant for her then?
There was an active warrant for the MTRP. She was arrested for these.
Right, and that warrant popped up in June in Florida.
Correct.
So from June 29th to today, she's been in custody, is that right? So
I
she
didn't try to
couldn't
open
report
anything, it just started doing stuff
to
on its
probation
own.
department. She's in custody from June 29th to today because she's locked up.
I don't care.
That's not her fault that she didn't report because she's in custody, correct?
She was in custody.
So she can't report.
Right.
As far as supervising her, she has reported, you say inconsistently, but that means she has reported some, correct?
Correct.
During the times that she has reported, have you been able to interact with her appropriately? She maintain proper demeanor, that type of thing?
She was, yes, but she was consistently late. I had to reschedule her several different times to get her into the office.
Have you had any other difficulties with her as far as just maybe perhaps being late or scheduling, as far as your actual interactions? Does she maintain appropriate demeanor, acted appropriately with you?
Yes.
Would you object to continuing the supervision?
I would.
Why is that?
My personal opinion, I don't think it's too close. She's for probation as a priority. She has been on probation, I think, since 2022 and has made no progress in regards to her fees. She did some community service, and that's about it.
When you say progress, how do you measure progress on probation?
Satisfying her court order conditions.
And how is she falling short other than the reporting and fees and community service?
If she committed
So
any
is this correct in the, hold on a second, hold on. Is in the updated report, it states that since she was granted supervision, has reported 6 times for scheduled office visits. Is that a correct number? Okay. 6 times since 2022.
I have another question, Your Honor.
Let's let Mr. Kimler finish.
If she were to be extended, which the court has the power to do, I mean, you would continue to supervise her, right? Or would you have a problem with supervising her for
I would work with her.
See any indication of need for some type of mental health referral or anything of that nature? I mean, I understand she's only reported 6 times, as the judge indicated. You see kind of programs or other things that probation could do for her to maybe perhaps to get her on the right track?
I think the only other option would be the cognitive job evaluation.
Pass witness.
Your Honor, is this the first time that we've been here on these 2 cases for a motion to revoke?
No.
Okay, there was another time back in 2024 in which we had a hearing similar to this, not me especially as the attorney, but she was brought in on a motion to revoke, and her probation was amended, and she was given 30 days in JCCL. and she was continued, and she was added to the mental health case.
The Jaime Nunez case, because she didn't report enough to be transferred over to the Jaime Nunez case.
So this is not even the first time that we've been here on this, on similar allegations. That was a year in 2024, we did the same deal. Is that correct?
I might follow up on that. I believe in the previous HURP, she had a motion, again, a motion to revoke. She had federal charges, is that right?
Correct.
The NTRP was filed after she received the federal charges,
I believe so, yes.
and she was housed in the cell unit. Were you supervising her then?
I
Or,
was not.
do you know if the detainer was placed on her for that NTRP while she was in federal custody?
I did not.
Did she actually do federal time while she was on probation for this case?
That is why the NTOB was dismissed.
So she received, I think, about a year sentence in federal court for misprision of felony. Is that consistent with what she did?
1 year federal probation.
Prison, she was locked up, right?
She got probation.
She had 1 year federal probation.
Probation, okay, for misprision? Or you don't know? What the offense was?
I thought it was a possession.
Okay. Anyway, she received a year of federal probation, so she was not revoked and was allowed to serve the probation concurrently.
Correct.
So during the period that she was on federal probation for that year, do you know if she was reporting to a federal probation officer, or any issues with the federal probation you're aware of?
According to Ms. Tebow, she successfully completed her federal probation.
And that was at the same time that she was on probation with Jefferson County. Is that right?
Correct.
Was she reporting to you during that time period as well? What was her reporting record in Jefferson County during that period? I guess it was probably back in 2024.
Well, she's reported 6 whole times so obviously it wasn't great even when it was then.
Right. But she was being supervised at least during that period federally, was able to successfully complete that probation, correct? Does that indicate to you that perhaps she could successfully complete Jefferson County probation if she's sufficiently knowledgeable?
She has the ability to, but whether or not she has the motivation or the want to do so.
I'd pass one, Jim.
All right, any other questions?
No, Your Honor.
All right, thank you, Ms. Simon. Any other witnesses?
No, Your Honor.
I would defer to Ms. Tebow, Your Honor, if she wanted to address the court. I think she has written to the court, and that letter's incorporated in the PSI.
I received it and read it. Anything else?
No, I mean, when I did fail to report it, sometimes I was hard with scheduling, but a lot of it had to do with my mother being sick, and I brought my mother sick to her office with me multiple times, because I wasn't able to just stay with where she was at. I brought her when I could. I mean, she's passed now, but at that time frame after.
But I mean, we're talking about since 2022.
I was in
Or
a
20
federal facility for a year and a day.
Okay. All right, so here's the thing. I'm not even sure where this agreement came from and why I accepted it in the first place, because giving somebody the minimum of 2 on a probation, so I have really nothing to do hardly on this. But Ms. Tebow, I mean, you've been given every opportunity over the last 4 or 5 years to do everything you're supposed to on this probation, and you've refused to do that. You flat out refused, and everybody, we all have different issues that go along with parents and family members and things that go wrong. And instead of, I mean, it looks like, I think one of the things that concerns me the most is that you called June 2nd asking why the police went to your home. June 2nd you called. And so your probation officer said there's a warrant because of your violations on June 2nd. Then you went to Florida and got arrested for 2 new offenses without registering, without obviously telling anybody where you are and the type of probation you're on, the offense that you're on probation for. That's probably the number 1 thing that you should do. So flee in the state when you know that there is a warrant for your arrest. Gives me no reason to leave you on probation. Unfortunately, I think for me and for the community, the most I can do is 2 years, and so that's what I'm going to do. I'm going to find, based on the evidence today, that counts 1 and 3 are true. So I'm going to find, you entered your pleas of true to 2 and 4 freely and voluntarily, find all 4 counts true. find sufficient evidence to revoke your probation. In cause number 22-39100, revoke your probation, sentence you to a term of 2 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 22-39101, also find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You need to sign that, please. I'm handing you the trial court certification that shows there was no agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that, and he'll give you a copy of that as soon as y'all get it signed. Thank you for being here. Good morning. Are you Leonard Guillory? And Mr. Guillory, in cause number 22-40982, on probation for unlawful possession of a firearm by a felon. That probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. It looks like the primary 2 allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
Yeah, it was with a vehicle. That's what, at least what the administrative hearing says, but
I don't know that it was with a vehicle.
I haven't seen anything about the evade.
I think
It was only the.
My recollection was that it was evading on foot. I'm happy to explore it.
That's okay, let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. And the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly was
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
Oh, ma'am, Judge, is just arguments.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Guillory had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case with the ag assault, understandably, it is would be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for the complainant witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before we come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than $200,000. A bond that high, a lot of bonds from the courts, it's hard. A lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or been going to court on that. My understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's obviously, that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that.
Yeah.
So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause, it's not public.
Gotcha.
I'm sorry, Judge.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is. Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it, and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information, because I don't feel like if that's going on, that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion, as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know. We'll get someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff.